Good morning, everyone. By the time of the chime, it is 10:30. Today, I believe, is March 16th, Tuesday. This is the House Commerce Committee. I'm Kevin Vaughn. I'll be your host today. And we are going to gavel into session and get commercial. Mr. Clark, will you call the roll?
Representatives Alexander, Boyd, CALFEE, Camper, Faison, Haston, Hazelwood, Hodges, Holsclaw, Johnson, Lynn, Manis, Moon, Powell, Powers, Sparks, Thompson, Towns, Zachary, Vice Chairman Bricken, Chairman Vaughn.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. Before we get started on our regular calendar, we're looking for folks who have personal orders. I see Chairman Boyd down there.
Thank you, Mr. Chairman. I have with me today folks out there somewhere, a young man named Luke Zellner, who's a 10th grader at Friendship Christian that shadowed me today. If you guys make him feel welcome.
One thing I can say about Luke, he's already learning the tenet that a strong handshake is a good attribute. I've already met him this morning. Anybody else got any personal orders? If not, we're going to get right down to business then. We're going to be working off of our calendar today, but just a little bit of housekeeping for those of you who are trying to figure out where to be and when to be there. House Bill, 72, which is item 5 on the calendar. We do have a request to roll that one to the heel of our calendar. So House Bill 72 will be rolled to the heel. First up today is House Bill 780, being presented by Leader Gant. Leader Gant, please share with us about this. We've got a motion. We've got a second. The bill is properly before us. Leader Gant.
Thank you, Mr. Chairman. I think we have an amendment. Is it traveling with it or?
004488. Is that your number?
That is correct.
All righty. We have a motion on the amendment. We have a second. Now the amendment is properly before us. Now let's talk about it.
Thank you, Mr. Chairman. The amendment does 3 things. It adds reporting requirement for commerce and insurance spends funds in extraordinary circumstances as allowed in this bill. Secondly, it adds language regarding confirmation of mail notification. And finally, there's a technical change made to section 13 of the bill that specifies a specific subsection of the code.
All righty. We have heard an explanation of the bill from Leader Gant. Do we have any? Yeah, we've got a motion and a second. It's properly before us. We have any questions for Leader Gant? I heard a question being called on the amendment. All those in favor of voting for Amendment 4488, which is Amendment 1, please signify by saying aye. Aye. All those opposed? Hearing none. Amendment 1 is attached. Now we're back to the regular bill. Has anything changed in the time that we just voted on that to now, Leader Gant?
I will renew my motion.
There we go. We do see a question. I have a question from Chairman Zachary.
Thank you, Mr. Chairman. Sponsor, I think it's important that we don't skip over this. And reading through this bill, I see words like reduce, clarify, remove, reduce, delete, remove, reduce, reduce. Those are the words that I have underlined. I think it's important to remember Tennessee is such a business-friendly state because we remove barriers to entry. And so while this, for most of us, will just be one that we vote and look at, and it's a good bill, this is the kind of bill that reduces regulation, that continues to make our state more environment. So I think it's important not to skip over that. Let the people know who are watching. This is why Tennessee is successful, because we continue to reduce regulation and continue to make our state more business friendly. So thank you for carrying the bill.
Thank you, Chairman Zachary. And I will obviously add to the record, this is an administration bill that does just as Chairman Zachary described. So thank you for that intro.
Leader Camper, you're recognized.
Thank you, Mr. Chairman. And I understand there is some reduce, remove, reduce, et cetera. Could you explain the bill a little more into detail?
Chairman, I can't.
Could you explain the bill a little bit more in detail?
Sure.
Leader Gant.
If you'll indulge me, I'll go through it.
Thank you.
This bill updates several procedures within the Department of Commerce and Insurance Division of Regulatory Boards. These updates include modernizing the way boards and programs and licensees communicate with one another, updating licensing fee structures or removing them altogether, decreasing certain age requirements, and lowering apprenticeship hours, which is what Chairman Zachary was referring to. This bill also makes updates to the Real Estate Commission's Education Recovery Account for simplifying requirements to access the funds. Secondly, this bill addresses recent court decision by removing the requirement for a potential barber student to earn a high school degree. This also addresses the discrepancy in the law that allows a cosmetology apprentice to work under any licensed cosmetologist while a barber apprentice may only work under a licensed barber instructor. Additionally, this bill simplifies licensing requirements for sole proprietors by only requiring one license instead of two. Within certain regulated professions, there are firm and individual licenses that can be duplicative for sole proprietors who operate their business as the only licensee, which is again what Chairman Zachary was referring to. This new exemption only applying to sole proprietors within the locksmith and funeral/burial services program will allow these licenses to operate under their individual license without the need for additional firm license or their main company that they work under. This bill removes a requirement for the collection services program, solicitor cards, and clarifies when scrap metal dealership licenses are needed. This bill also allows for regulatory boards easier access to their reserve fund accounts for specified uses, and we can go into that if you'd like, Chairman Camper, as well. But I yield back to you, Mr. Chairman.
Thank you, sir. Leader Camper?
I'm good. Thank you, Mr. Chairman.
Thank you. Do I have any other questions with regards to this bill amendment? Representative Alexander.
Thank you, Chairman.
I see.
It's okay. I'm
I
sorry,
see.
sorry. Representative Gant, you mentioned funeral homes. So we have a business permit because I'm a funeral home owner. I just want to make sure I understand that. We have a business permit for our funeral home. My husband has a director's license. Our embalmers have a director's license and a embalming license.
Right.
So will that change any of that?
It's a good point. Now, what I'll do is I'll clarify that. with
Later,
what
Gant.
the actual bill does.
You're recognized.
I'm sorry, Mr. Chairman.
Sorry.
Please forgive me. Under the current law, licensed funeral directors selling pre-need contracts on behalf of their own establishments are required to obtain a separate pre-need sales agent license.
Okay.
This proposed legislation will create an exemption for those sole proprietors who are licensed funeral directors and selling the pre-need contracts on behalf of their own establishments, that they will no longer need that duplicate additional license. Does that make sense?
Absolutely.
Okay.
Thank you for
All right. Thank you.
clarifying that.
Anyone? Representative Sparks.
Yeah, I just want to thank the member for carrying this bill, and we need more of it. Maybe this summer we could maybe put a task force together and look at other efficiencies and deregulation, if you will, to help people be able to. The apprentices, I think lowering that age was really wise too. So just want to say thank you.
Thank you, Representative Sparks.
Yes, sir. Any other takers? Okay, we see no more comments. We're going to call the question. This is House Bill 780. All those in favor of House Bill 780, sending it on to Finance Sub, please signify by saying aye. Aye. Any opposed? Seeing none, you're off Finance Sub.
Chairman, it's always good to be in your committee and be with your committee. Thank you.
Thank you, Leader Gant. Next up, well, once proper sanitation procedures have been employed, we will be listening to Representative Russell describing House Bill 177. We got a motion and a second. You're properly before us, Representative Russell. I believe we've got some amendment homework to do here as well.
Yes, sir, Mr. Chairman. I've got amendment 04516.
We got a motion and a second on House Amendment number 2. All those, we've got a motion and a second. Could you explain to us what we're doing here?
The amendment makes the bill, it's a simple bill. It just says a manager, property manager may testify against a tenant under this chapter in the same manner as a landlord or owner.
All righty, do we have any questions for the sponsor? Any questions? We've got a question on the amendment. All those in favor of the amendment, please signify by saying aye. Aye. Any opposed? Hearing none. House Amendment number 2 goes on the bill. So now we are on the original bill. We've got a question on a bill. All those in favor of House Bill 177 as amended, please signify by saying aye. Aye. Any opposed? Hearing none. You're off the calendar and rules.
Thank you.
And just for those keeping score at home, House Amendment 1 was my amendment that was not put on in subcommittee, so we did not have to put it on. We did not have to take it up here. Representative Russell, always about to say Representative Lowell, his amendment did what needed to be done. All right, now we've got House Bill 830 by Chairman Kumar. The bill is properly before us. Chairman Kumar, it's good to see you today.
Thank you, Mr. Chairman. We do have an amendment, code 4847.
We've got that, and you, sir, that amendment is also properly before us. Please share with us what we're doing.
This amendment, the bill has to do with limit law for farm machinery and tractors. And this amendment adds that the lien holder will be informed when such an exchange occurs that the current tractor is replaced by a new one. This is what the amendment does.
All right. Do we have any questions on that particular amendment? We got a question call. Seeing no questions, we will honor the question. All those in favor of amendment number 1, please signify by saying aye. Aye. Any opposed? Hearing none. Amendment 1 is now on the bill. Talk with us about these lemons and tractors.
It's a wonderful bill. We all know about the lemon law for automobiles. Surprisingly, there is not one for farm machinery or tractors, although it's much more expensive. So this bill brings the same concept to protect consumers from expensive machinery that does not work properly and is a lemon. There's a 12-month period during which the machinery can be evaluated. If the cost to the farmer runs more than 3 repairs equaling 30% of the cost of the machinery or 5 repairs equaling 50%, then the consumer is entitled to either a full refund or replacement with a likewise machinery. And surprisingly, and it was very good during my work with this bill, that the manufacturers, the distributors, as well as the banking people were all have worked with me on it. And the Farm Bureau especially, I'm grateful to them for their work. And this is a joint effort that is acceptable to all parties. Thank you, Mr. Chairman.
All righty. Do we have any questions for the good doctor? Any questions? Seeing none, let's vote on this bill. Hopefully this is going to get him on the cover of Progressive Farmer magazine. All those in favor of House Bill 830, please signify, and we've attached the amendment, so now we're on the bill. House Bill 830 by Chairman Kumar, please signify by saying aye. Aye. Any opposed? Hearing none. House Bill 830 is off the calendar and rules.
Thank you, Mr. Chair and committee.
Next up, Chairman Reagan is going to share with us about House Bill 728. Sir, you are properly before us.
Thank you, Mr. Chair. This bill comes to us from the Government Operations Reviews. We have 2 boards, the Credit Services Business and the Board of Debt Services businesses that are considered essential. However, one of them does not comply with TCA 4-29-121, which says it must be financially self-sufficient. Without doing something, the Government Operations Committee would have to put this entity into wind down and dissolve it. However, the department suggested that we combine the financial resources, one of which is in a surplus and the other in a deficit, so that both of these would be operating financially self-sufficient. They would continue to do their work. With that explanation, if there are no amendments, I stand ready to answer questions.
All righty. Thank you, sir. Do we have any questions for the good chairman? We've got a question on that bill. Let's honor that question. All those in favor of House Bill 728, please signify by saying aye. Aye. Any opposed? Hearing none, House Bill 728 is off to calendar and rules.
Thank you, Mr. Chairman and committee.
And as we had previously disclosed, House Joint Resolution 72 by Representative Todd has been rolled to the heel per his request. Next up, House Bill 334 by Chairman Hicks, and as looking at the title "Death" as introduced. That's quite the caption there, Chairman Hicks. We've got a motion and a second. You're properly before us. We can't wait to hear more about this.
Thank you, Mr. Chairman. I can't wait to tell you more about it. Mr. Chairman, this bill creates regulations and requirements on the operations of alkaline hydrolysis facilities, requires the operator of an alkaline hydrolysis facility to receive a permit from the Department of Health for reclamation of human remains. And with that, I'll be ready to answer any questions.
We have Representative Chairman Holtzclaw. I believe you have a question.
Thank you, Chairman. We appreciate you bringing this bill to us, Representative Hicks or Chairman Hicks. We had discussed in the past that the alkaline hydrolysis process takes, what, 6 hours or so to complete?
Yes, sir, Chairman.
From my understanding, and of course, I'm not the resident expert on this, but it's about 4 to 6 hours from what I have been told.
Chairman Holtzclaw.
So how long does it take to get your hair down to that process using this chemical?
It's about 4 to 6 hours.
Okay. Thank you, Chairman.
Looks like they may have put too much on mine. Any other questions for Chairman Hicks? Chairman Faison.
Thank you, Mr. Chairman and Chairman Hicks. We were just wondering if you could actually spell alkaline hydrolysis without looking at it.
You don't have to attempt this, Chairman Hicks.
Thank you, Mr. Chairman. I will say this. I may not be able to spell it, but I can sure say it. And I've been practicing, and I'm pretty proud I've not messed up yet saying it. So I would love to say it again if I could. Alkaline hydrolysis.
Before we devolve any further, I think we're going to call for a question on this bill.
Thank you, Mr. Chairman.
All those in favor of House Bill 334, sending it on to calendar and rules, please signify by saying aye. Aye. Any opposed? Seeing none, 334 is off the calendar and rules.
Thank you, Mr. Chairman and committee.
Representative Cochran, we can't hear you over there. Next on our calendar is House Bill 205. We have a motion and a second. You are properly before us, standing behind that sanitized microphone.
Thank you, Mr. Chairman. I'd like to make an entrance. I appreciate you. Yes, so House Bill 205, it's really bringing utility districts that are jointly owned by 2 or more counties. It's bringing their compensation level up to those that municipal districts, to the level that municipal districts are already paying their members. So happy to answer any questions, but essentially there are very few of these utility districts in the state. Probably when the municipal districts were brought up to $300, these were kind of just left out. So just kind of updating the code.
All right, need to take care of some housekeeping on this one. We have an amendment that I believe makes the bill.
That's correct.
Drafting code 4115. We got a motion amendment. Now that amendment's properly before us, we got any questions for Representative Cochran? I don't see any, so we are voting on amendment number 1. All those in favor, please signify by saying aye. Aye. Any opposed? No. Amendment 1 is attached to House Bill 205. Now we are on the bill. Any questions on the bill? Seeing none. Oh, wait, Leader.
Thank you, Mr. Chairman. I was just wondering, did the amendment rewrite the bill? So if what you explained to us before
Yes,
was
ma'am.
the actual
Yes.
amendment that went on the bill?
Yes, ma'am. That amendment is the substance of the bill.
And the amount, what is the difference in the amount of money that we're talking about?
So,
It's okay to go to the second question? Okay.
yes, Leader Camper, yes, the current allowable amount for these utility districts is $100 a meeting. This does not mandate, but allows $300 a meeting. And that's what your municipal utility districts are allowed to pay currently as well.
Leader Camper, you're recognized for a follow-up.
Thank you, Mr. Chairman. Thank you, Mr.
Thank you.
Sponsor.
All right, y'all, I was about to get on a roll there. Y'all throw the brakes on anytime you need. All those in favor? Oh, excuse me, we have another question. Representative Towns, took me literally.
Mr. Chairman, thank you. Correction, I understand that it may not be per meeting, but it's rather per month. Is that correct? Versus per meeting?
Yes, I will, let me check that. It is per month. You're
Very
correct.
well.
That's, but my apologies. Typically those are monthly meetings a lot
No
of times.
problem.
But yeah, I misspoke. You're correct.
Thank you, Mr. Chairman.
All right. Does anyone have a question? Oh, thank you. See,
Thank you.
we were calling the question on House Bill 205. We're looking at needing to send this to the Finance, Ways and Means Subcommittee. All those in favor of doing so, please signify by saying aye. Aye. Any opposed? No, we do not see any. So House Bill 205 is out of here, headed to Finance Sub.
Thank you, Chairman and Committee.
Next on our calendar, House Bill 388 by Representative Darby and others. Got a motion and a second on the bill. You're properly before us, Representative Darby. Share with us how we're going to change the world with this piece of legislation.
Thank you, Mr. Chairman and Committee. HB 388 authorizes Tennessee utility districts to use a request for proposals process. State government and cities and counties and municipal utilities have been using RFPs for several years. This bill would simply extend the same authorization to utility districts.
All right, do we have any questions for Representative Darby? All righty, seeing none, I think we're going to vote on your bill, Representative Darby. This is House Bill 388. All those in favor of sending it to calendar and rules, please signify by saying aye. Aye. Any opposed? No, I do not see any. So 388 is off to calendar and rules.
Thank you, Mr. Chairman and Committee.
Yes, sir. All righty, we're going to stay within the confines of our committee for the balance of the calendar until we get to the heel. So in front of us now is House Bill 401 by Chairman Boyd.
Motion.
We've got a motion, we've got a second. We see no amendments, so Chairman Boyd.
Thank you, Mr. Chairman, Committee. This is dealing with a provision that was put in statute a few years back dealing with workers' comp court systems, and it allowed in cases where an employee was wrongfully denied benefits by either an employer or an insurance company, provisions in place so that the judge could award attorney's fees in those extraordinary circumstances. This was passed last year, and unfortunately with the COVID pandemic, the Senate did not carry it. And so it actually is set to sunset every 2 years. And so it has actually sunsetted. And what this would do would extend it until June 30th of 2023. I'll take any questions, Mr. Chairman.
All righty, thank you. We got any questions for Chairman Boyd? Any questions? Let's call that question. Let's say House Bill 401 headed to calendar and rules. All those in favor, please say aye. Aye. Any opposed? No, seeing none. We're going to send 401 to calendar and rules. And just, we can avoid sanitization procedures again. Just hold what you got there. Chairman Boyd, share with us about House Bill 1285.
Thank you, Mr. Chairman. And I do have an amendment on that, Mr. Chairman.
Yes, we're tracking 4593 along with you.
That is what I'm showing, Mr. Chairman.
All righty. We got a motion on the amendment. We got a second. Share with us about the amendment there.
Thank you, Mr. Chairman. This bill and the amendment makes various changes to the workers' comp code specific to misclassification of employees. There's one portion of it dealing with subpoenas for employers and third parties such as accountants, tax preparers, insurance agents, carriers, and bank institution, and how the workers' comp is able to get those and various penalties. It also deletes and rewrites a section that would set forth a process when an employer understates or misrepresents an employee's number, payroll, or job duties, as well as an employer's failure to secure and maintain the payment of workers' compensation insurance, and it would be $1,000 or 1.5 times the avoided average yearly insurance premium. I'm happy to take any questions, Mr. Chairman.
I see no one wanting to be recognized. Everyone, I believe, is comfortable with your command of the workman's compensation situation here, Chairman Boyd. So let's vote on the amendment number 1. All those in favor, please say aye. Aye. Any opposed? Hearing none. Amendment 1 is on the bill. Anybody want to talk about the bill other than Chairman Boyd? We've got a question. We will honor that call for the question. So we are looking at House Bill 1285, heading out to calendar and rules. All those, please, who agree with that, say aye. Aye. Any opposed? No no's. You are off to calendar and rules, Chairman Boyd.
Thank you, Mr. Chairman. Committee.
Next on our calendar, we see Representative Alexander and House Bill 651. We have a motion and a second.
Thank you, Chairman and committee. If it's okay, I'll just stay seated where I am.
We want you to be the most comfortable you can be, Representative Alexander. So if you're going to drive from there, we are good with it.
That's good. The bill I bring before you is from the Comptroller's Office. The legislation makes government work better by removing an unnecessary statutory provision in the definition of financial distress for government utilities. This bill removes the requirement for pension and OPEB activity to be excluded from the calculation of the statutory change of the net position for government utilities. Under this change, utilities will no longer come under the purview of either the UMRB or the WWFB solely for funding their pension and the OPEB liabilities, while utilities that need board assistance will be referred. The Tennessee Association of Utility District supports this bill.
Question on the bill. Thank you. We see a question on the bill. Anyone have any? Oh, well, we're honoring that question. All those in favor of House Bill 651, please signify by saying aye.
Aye.
Any opposed? No. House Bill 651 is off to calendar and rules. Good afternoon, Chairman, or good morning, Chairman Moon. Let's talk about House Bill 188. Motion. Second. You're properly before us, and I believe you also have an amendment traveling with this bill?
That's correct, Mr. Chairman. Thank you. It's Amendment 4799.
It is. We've got a motion and a second on that. It's properly before us as well.
This amendment makes the bill. It authorizes members of the United States Armed Forces and honorably discharged veterans to receive equivalent credit toward the receipt of an occupational license related to their military training. It sets up an appeal process, and it also directs the Commissioner of Commerce and Insurance to collaborate with the Commissioner of Veteran Services to draw up the rules. And with that, I'll entertain any questions.
Questions been called on the amendment. Any objections? Seeing none, all those in favor of approving Amendment 1, please signify by saying aye.
Aye.
Any opposed? No. Amendment 1 is now on your bill. Question on the bill. House Bill 188. All those in favor, please signify by saying aye.
Aye.
Any opposed? Ayes have it. You're off to GovOps.
Thank you, Mr. Chairman and member.
I'm going to pass this down to Vice Chairman Bricken.
All right, Chairman Boyd, recognized on Bill 1112.
Thank you, sir.
Motion.
Second.
Thank you, folks. What this bill does, looks to standardize safety protocols on job sites across the state. It brings contractors deal with a lot of activities on different job sites that work in different jurisdictions. What this will do is we'll be adopting TOSHA and OSHA as the federal and state standard will apply across the board. We know that during subcommittee, Representative Thompson brought up the fact of the impact to localities. What this does is, right now, local governments have a say in the aesthetics of what they look like. They also have a say in the codes of how things are to be constructed. What this does is this sets statewide standards for the management of the job site itself, so that a contractor will know how to behave in Humboldt the same as it does in Bolivar, the same as it does in Collierville, the same as it does in Nashville. So that's what this bill does.
Any questions on the bill? Representative Camper?
Thank you, Mr. Chair. Mr. Chairman, is there some instances in some of the major metropolitan areas where they might need to put some other restrictions in place that this would affect?
I am not aware of any specific. I understand that there is, I will be as candid as I can be. This is contemplating issues, and it looks to get it to where it's taken care of before things get started. That's my understanding. This was brought to me by the Association of Building Contractors.
Representative Camper?
Thank you, but you believe that by passing this legislation, it would make it easier, I guess, for all of the general contractors to fulfill their obligations, to make sure safety is in place, if they're doing business from one county to the next, or am I reading that correctly?
Yes, ma'am. Oh, excuse me, Chairman.
Recognize.
Yes, ma'am. That is the purpose of it, because typically what you see in construction contracts and job sites is that the specifications rules, which have been designed around local codes, and then whenever they're going through their entitlement procedure to get their permits and such with a town, there's requirements there as well. What this says is once the job starts, the contractor has OSHA and TOSHA reporting responsibilities and has standard record keeping no matter where they are in the state.
Representative Camper?
Okay, thank you, Mr. Chairman. So you don't see this as potentially creating some problems on maybe some projects that's already ongoing, that's in place? And if we pass this legislation, it could interfere with any of these jobs that's currently going on, or is this like going forward so that, I mean, if there are some procedures that some local governments have in place right now, I'm not saying that they are, but if there are some, this bill would not interfere with that particular operation that's going on right now. It's a lot of development going on here in Nashville. We see cranes everywhere. And so it's a lot of work going on. And I'm wondering if we pass this bill, would it impact any of those, or it's just like going forward, this is kind of how we're going to do it?
Chairman Vaughn?
Thank you. Leader Camper, my understanding, and I wasn't even pre-law for a semester, so I don't know anything about this, but I do believe that it would pertain to contracts entered into after the effective date of the law. And so what is happening now wouldn't, but moving forward, it would.
Thank you, Mr. Chairman. I just wanted to make sure it was on the record that way so that we wouldn't, interfere with any ongoing operations. So thank you. I appreciate it. Thank you, Mr. Chairman.
Thank you. Representative Sparks?
Thank you. Chairman Vaughn, would you call this a very pro-business piece of legislation?
Chairman?
In my understanding, it is, Representative Sparks, it's the construction industry is fraught with requirements, regulations, codes, and responsibilities.
Yes.
What this does is this allows people to understand that they're going to be, the same is going to be expected of them. And I think that to what my understanding, what Leader Camper was saying, is that is that a contract would, a contract that is for somebody building something in Bolivar will be under the same safety requirements that they would be in Memphis.
Yes.
And so from that standpoint, we think it's both a pro worker and a pro business, so, because that standardization allows people to be able to gain efficiencies by being able to work through that.
If
Representative?
I just want to remind the committee and maybe folks watching, we're seeing that we've got an affordable housing crisis in Middle Tennessee. I've got an affordable housing crisis in my community. The average cost of a new home today, $83,000 is just government regulation, fees, and taxes. $83,000. Now, someone's willing to correct me if I'm wrong. That was according, I think, 2018. But I just want to thank you for this, and I just want to remind folks: every time we put more barriers to entry on businesses, we're driving those costs up. So, thank you for your piece of legislation, sir.
Thank you. Representative Hazelwood?
Thank you, Mr. Chairman. I just wanted to say thank you for the legislation. Having spent some time working in economic development, I know that businesses like to have consistency. So it's important to a business to know that no matter where they're operating in Tennessee doing a construction project, that the rules are going to be the same. And I think it's important to note that those rules are TOSHA and OSHA, so we're not giving up anything in terms of safety or any of those things. So again, I think it's a good piece of legislation. Thank you.
Thank you. Any comments, Chairman? Well, Representative Towns had a question, I think.
I'll just simply call the question. No problem.
I hear the questions called. Seeing no objections, let's vote on House Bill 1112 and send it on to calendar and rules. All in favor, say aye. Aye. Any opposed? Hearing none. Bill passes on to calendar and rules.
1039, we're without any objections, we're going to roll that 1 week. House Bill 1039. So now we find ourselves back, or we're at the heel of the calendar, where Representative Todd requested to be.
Second.
We got a motion and a bill. It's actually a House Joint Resolution. House Joint Resolution number 72 by Representative Todd. You are properly before us, Representative Todd.
Thank you, Mr. Chairman, committee. First, what this bill does, it enshrines our right to work laws into our state constitution. What is right to work? Put simply, it says workers cannot be fired or penalized for joining or refusing to join a union and pay union dues. Ultimately, right to work is about protecting worker freedom. If a person wishes to join a labor union and pay dues for the union's representation, he or she should have every right to do so. But if a worker wishes to remain independent and not contribute his or her hard-earned income to union dues, he or she should not be forced to do so. That's precisely the decision that our right to work law protects. This has been the policy in the state of Tennessee since 1947. Like other states that have adopted this policy, we have reaped the economic benefits of it. Studies show that right to work states have higher income levels, employment growth, and population growth. The best way to ensure that we remain a right to work state and protect worker freedom for generations to come is to place it in the state constitution. We knew how important it was to refuse to adopt a state income tax, and we didn't just refuse to do so, we banned one in the state constitution. So this actually puts this law into the state constitution as we did the opposition to state income tax. So with that, Mr. Chairman, I'll be glad to answer any questions.
Excuse me, we have folks here to testify today, I believe, on this matter. And the way I'd like to do this is I'm going to give each side 5 minutes to present the opposing viewpoints. We'll have point counterpoint right here in hearing room 1 today. So what we'll do then is, following that, we'll go out of session for that. Any questions that you may have of any of these witnesses or providing their viewpoint, we'll give you a couple of minutes for a couple of times for that. Then we will go back in session and take questions for our sponsor. So any misunderstandings about that? None. We're going to go out of session. And first up we are going to hear from, I believe, Mr. Billy Dykus from the AFL-CIO. Are you here, Mr. Dykus? And sir, if you'll come down, tell us your name for the record. Yes, sir. Any one of those spots, and you can punch that microphone when you're ready to go. And what we'll do is, if you see me doing this, that means wrap her up, because we're going to take it about 5 minutes at a time. And thank you, sir, and you're recognized.
Sit down now. Well, thank you, Mr. Chairman and members of the Commerce Committee. My name is Billy Dykus. I'm president of the Tennessee AFL-CIO. I'm here to speak to you today about working families' opposition to House Joint Resolution 72, also known as the Right to Work Amendment. When it comes to conversations about this amendment from the proponents in the business community, we've heard a lot about Virginia, other states. There's right to work issues in Montana, New Hampshire. Anyone that's followed it, there was right to work issues in Wisconsin, Michigan. Recently, Alabama passed a right to work amendment. The part of this process that's really, is kind of confusing to me is we live and work in Tennessee. We don't live in Michigan. We don't live in Wisconsin. We don't live in Montana, Maine. We don't live in Alabama. And even though some football folks would like to be there, I think occasionally, myself included, if I could win a few national championships here in Tennessee, I'd be a happy man. But the truth of the matter is, we're talking about a constitutional amendment that only 10% of the people, less than 10% of the people in this state are represented by a labor union. So we're going to pass a constitutional amendment to protect 90% of the workers for something that they don't even belong to. It's really and truly, it's kind of frustrating. And I'd like to read a statement from Representative Todd at last week's subcommittee. And this is a direct quote. It simply protects the worker who does not want part of their paycheck going to support a labor union that they feel no benefit from or they disagree with for some reason. That's all it does. It's really an individual right that I think each one of us has not to be forced to join some kind of organization and pay them money for something we disagree with. As you can see, even the House sponsor is more concerned about something that don't exist. Even with the current law that's been in play for 74 years, that's always been a right. You don't have to belong to a union. That's what right to work means. It's a choice. It's been here for 74 years, and we're talking about doing something that's been here for 74 years. Not any time has ever legislation been brought before this body under the prior administrations up until now where people were trying to overturn this right to work law. We've worked within it as union members. We understand it. And sometimes you have to understand, if you don't belong to the union, you're no good to the union. If you're not in the union, we're only as strong as our weakest link. So not being in a union sometimes helps us understand where we are as membership. Sometimes we work harder because our members are not in the union. So we work hard to convince them what it means to be a part of a union and collectively have a voice. One thing that I do want to talk about today is the issue of civil rights. It's been brought up. It was brought up last week in subcommittee. It's been brought up by the Senate sponsor numerous times when he talks about this, that it's a civil right to belong or not to belong to a union. The Senate sponsor was actually asked on the Senate floor this very thing. Could this constitutional amendment be potential for litigation that could arise from putting it into the Constitution? And he said it could likely happen. The resolution does not change the fact that people are being fired for wanting a union in the workplace and facing constant intimidation and harassment from union-busting lawyers who are hired by companies to influence what's supposed to be a free and fair election. If you've never been involved in an organizing campaign, and I have many, I've yet to see someone not be fired or a company not hire sometimes from Texas, lawyers from Texas to come in and meet with the workforce and tell them all kinds of stories about how bad we are. That's not allowed from our perspective. We have to meet with people off-site. So it's not a fair and free election. It's never has been fair and free, but we live with it and we deal with it. Have we become so far detached from working people that those who represent them have now become numb to their concerns over political favors and this constant skies falling mentality? If we're going to ask voters to consider codifying right to work in the Constitution, might as well ask them to do the same with protecting their civil rights that are being violated in the workplace every time someone wants a union in their workplace. I appreciate your time, and I'm willing to answer any questions. Thank you.
Thank you for your remarks, and 4 minutes and 56 seconds. That, sir, was impressive. All right, we have questions for the witness. Any questions for the witness? Representative Thompson.
Thank you, Mr. Chairman. Just wanted to understand one thing you mentioned in your presentation. So you said there's a possibility of outside interest bringing litigation against businesses, whether it be to have or have not a union. Is that what you're getting at?
Representative Thompson, there has already been inquiries into the potential litigation over where we're headed with this constitutional amendment and the rights to belong or not to belong to a union, especially around organizing. A lot of times you don't understand what a union is. And most people, I come out of a major tire manufacturer here in the state. Most people think that belonging to a union means you go to work somewhere and you go in and you decide to be a part of the union or not. That's not all what it's about. There's a lot of efforts afoot. And I don't know if y'all noticed, but there was a recent poll done where 64% of the people in the United States feel like labor unions are important and they feel like they're a part of what we need going forward. So there's more to it than just going into the workplace. There's organizing campaigns. And I'm here to tell you again that I've never been a part of an organizing campaign where someone wasn't fired. That's handled under the Department of Labor guidelines now. And majority of the time, we argue that one, the person should be restored to whole, and the other, he should be allowed to vote in the upcoming election. That normally happens. What doesn't happen is the person don't go back to work. One of the deals that's worked out in that negotiations with the Department of Labor is that person is separated from employment. He gets some amount of monetary pay. Sometimes it's up to a year. I've seen them pay up to a year. The company doesn't want that employee back because he's a union-friendly employee. He does get to vote in the election. So there's a lot of issues that are ongoing, and look, there's good and bad in both sides of this issue, and it's difficult. I will say this though, in the state of Tennessee, and I would challenge any of you, and even some of my friends from the business community, we as union representatives have the best working relationship with the companies that we represent, and I can take that to any other state in this country. We go out of our way to be a part of labor management, to work through our issues. The tire plant that I come out of is in the top 5 in the world in every category, and the average salary is almost $29 an hour. So we are able to compete because we work with management and we work with business because, hey, if business is not successful, we're not either. So I think that, we're jumping the gun on something that we really don't have to do. And I'll apologize if I ran on too long.
No, thank you, sir. Do we have any further questions from Mr. Dicus? Chairman.
Thank you, Mr. Chairman. I certainly want to thank Mr. Dicus for being here. He's a native from Bedford County, but he currently lives in the wonderful 47th District in CALFEE County. I've known Billy for a while now, and he certainly provides a lot of quality leadership to the workers in Tennessee. He's always been fair, and I think and uses a lot of common sense in his dealings in every way that I've always known him. So anyway, I want to thank you for being here and thank you for your leadership.
Thank you, sir. Representative Sparks.
Yeah, Billy, I just wanted to we've had great conversation, AJ as well. Recently I had Jim Brown at my Rotary Club, and I know Jim's probably thinking, uh-oh, what's Sparks fixing to say? He's scared. But it was back at my Rotary Club in Smyrna, and he really talked highly of y'all, about the great camaraderie back and forth. He talked about his book about, I think, civility. I don't know the name of it, Jim, I'm sorry. But I just want to thank you. You know, I've worked in a factory. I've seen my coworkers pass out in the summer months. I never felt like I needed a union. I was a good employee, prayed every day to leave that factory, and the good Lord opened the doors for me. But I appreciate your attitude. You've always been great to deal with. We could agree to disagree. And I like the back and forth that y'all have, even that there's some areas y'all find common ground. So I'm probably going to vote for the bill, but I just want to thank you for just how you handle yourself. And I think you make a great ambassador for who you represent. So thank you.
Thank you, sir. Representative Towns.
Mr. Chairman, thank you as well. And Billy, always thank you for the presentation, you and AJ. Always. I guess my concern, Mr. Chairman, is that we call it a right to work state, and you ain't got no right to work. It's an oxymoron, because people can be let go for anything at any given time. I mean, I used to think that was the case when I didn't understand what that term meant, but it's not what it says at all, okay? So I think we ought to have truth in how we describe some of these things, because it can confuse young people in particular. But I guess, you know, and I love what you said in terms of being able to work together with corporations, because if you don't have corporations, obviously, it impacts our entire community. So business and labor, as much as possible, and there's not going to always be a happy marriage, but as much as possible, you want to work together. But Mr. Chairman, my concern would always be, so what are we adding to, you know, our sacred documents that we all hold dear in the state and at the national level, whether we adding things that we should or should not, okay? Even with the income tax, while many of us oppose the income tax, I was not readily, you know, and I think it's been good for our state, but I was not readily available to put it in our Constitution at all. But thanks for your presentation.
And looking for the last questions for our witness, Mr. Dicus, Representative CALFEE.
Thank you, Mr. Chairman. Billy, thank you for being here. I've had a great relationship with you and AJ for about 8 years now, and it's more of a statement than a question, but I'm probably the only Republican member of the House of Representatives that ever belonged to a labor union. And I've actually been part of an organizing effort back in the 70s at the K-25 plant in Oak Ridge for the weekly salaried employees. And it was rolling along pretty good. And then we got about a 15% raise, and that's the end of that. So you know how that works. Now, my dad was a Teamster for 30 years, and his philosophy, he started at the Y-12 plant in Oak Ridge in 1951. And his philosophy was, I'm a union member, I've got some protection, I get better pay of it, and what have you, and I'm obligated by that to do a better job than non-union people. Now, having said that, in the 70s, a lot of young folks were kind of taking over the unions, and their goal was to do as little as possible, and I see you're agreeing with me, and still keep a job. Well, that's faded away pretty much now, and I've got a lot of friends who belong to labor unions, most of them construction workers, and I was really having second thoughts about this. We talked about this the other day, and in our United States Congress passed a bill in the House of Representatives to do away with the right to work in 17 states, Tennessee being one of them. Of course, as I think AJ and I talked about this morning, it probably never passed the Senate. But I'm going to have to vote for this because I don't want to take the risk of us losing the right to work, and I don't think it'll affect the labor unions in any way. I don't think it'll hurt the labor unions, and so I'm going to vote for this. Thank you, Mr. Chairman.
I've got to turn on my button so the world can hear me. We're going to release you, sir, to go back to your chair. We thank you for your well-reasoned arguments, and thank you for sharing some time with us today. And for the counterpoint, we're going to be hearing from Justin Owen with the Beacon Impact Center, Bradley Jackson with the Tennessee Chamber of Commerce, and Jim Brown from the National Federation of Independent Businesses. And y'all get to, well, I see we've got, that looks a lot like Ryan King. So you guys get to cut up your 5 minutes. Let's see if you can get as close to it as Mr. Dicus did, but the floor is yours.
Well, thank you, Mr. Chairman, members of the committee. I'm Justin Owen with Beacon Impact, and I'm here today to ask you to support HJR 72. A right to work really is a Tennessee tradition. It's something that we've long held valuable in our state, the right to decide whether to join a union and pay dues, or the right to choose not to do so. It's also been played a very instrumental role in our economic growth as a state, in addition to being such a fundamental right. Unfortunately, this has come under attack, both nationally. Just last week, the U.S. House of Representatives passed the PRO Act, which would ban right-to-work laws nationally. Our neighbors in Virginia, who have been right-to-work since 1947, just like Tennessee, have tried for 2 straight years to repeal it there. So we believe that the best way to protect this right here for generations to come is to put it in our state constitution. As Representative Todd said, this is exactly what you did as a legislature with the income tax. You not only refused to enact one, but took the steps to ban one in the state constitution, putting it before voters in 2014, where 2/3 of them voted yes on Amendment 3. We believe the right to work is equally an important part of our economic success story. We're just as proudly right to work as we are income tax free. And Tennesseans agree. 68% of them, according to a Beacon Center poll, said that they would vote to put this in the state constitution. And so I'm here today to ask you to give them that opportunity next November. Thank you.
This one, am I on? Okay, good. First of all, Jim Brown with NFIB. Thank you, Representative Sparks. Thank you for your comment earlier. I was at the Rotary Club, and we do have a lot of things that we do agree on. And I think that bill earlier that Chairman Boyd passed on workers' compensation with misclassification, that's something that the unions and the business community agree on. So there is a lot to celebrate in this state. That's a good bill that you passed, Chairman Boyd. It's 27 states that would lose right to work if the U.S. Senate passes that legislation that the U.S. House of Representatives passed last week for the second time in 2 years. So we wouldn't be here unless what was going on around the country. Mr. Dicus mentioned Virginia. That also has our attention, not just what's going on in Congress with the effort to eradicate right to work laws, but last year they tried to repeal, very serious effort to repeal their right to work law, which has been on the books since 1947 in Virginia, 70 some odd years, and 1947 for us here in Tennessee. First state was Florida in 1943. It was bipartisan back then. Everyone locked arms and said, this is good for workers, this is good for business. So that's why this came about as a reaction to Taft-Hartley back in the 30s. It was Governor Northam, a Democrat in Virginia, that spoke out forcefully that we don't want to do this in our state. I'm good with some other things that the unions are advocating for, but this is not what you want to do in Virginia. And we appreciated Governor Northam doing that in Virginia. He said it was bad for the state's economy and it would hurt choice for workers. A couple of quotes from the Biden administration also has our attention. The president said we should change the federal law so that there's no right to work allowed anywhere in the country. And Vice President Harris in 2019 in Las Vegas, I believe, in an SEIU event, said banning right to work laws has to happen. This resolution has the strong support of small business. We just polled this in January. Nearly 3 out of 4 NFIB members support putting it in the Constitution, more support right to work, but it's because of what's going on in the country. So in conclusion, let's protect workplace freedom and choice in Tennessee. Let's send a message to what's going on in Congress. We don't like what's happening up there. And let's give the voters the chance. You all are merely authorizing the voters to give the voters the chance in 2022 in the next election. So thank you very much.
Thank you, Mr. Chairman and committee. Ryan King with the Tennessee Chamber, and it's good to be with you all, and it's good to talk to you all the past
couple weeks about right to work, something that's very important to the chamber, obviously, and our partners here, and especially Chairman Todd. Thank you for your passion on this issue. You've been very passionate about it. As you all know, this is a bedrock doctrine to Tennessee. It's something that's been on the books since 1947, over 70 years. And what we're looking to do here is not change the policy of the state, but elevate this policy to the state constitution. We think that it's so closely held in Tennessee and been such a driver to our business climate in Tennessee that we want to elevate that. So I'll be very quick. What we want to really convey from a chamber standpoint is that our members overwhelmingly through our annual survey think right to work is the right thing to do in Tennessee, and elevating it into our Constitution is the right thing to do. And most importantly, we hear from a number of employees almost monthly who are thinking about moving to Tennessee that this is the number one check the box item. Are you a right to work state? And of course we are.
And thank you, gentlemen, for sharing that with us. We're going to ask you to wrap. We're going to consider that a wrap. Do we have any questions for these folks? I've got I have several. I saw Representative Towns first. We're going to start with him.
I'll make it brief, Mr. Chairman. Thank you. Gentlemen, either one can respond. In the event that this actually right to work is banned at the federal level, how does it impact us in Tennessee now?
If that law passes Congress?
Yes, sir.
Well, we'd have a fight on our hands. I believe you'd have 27 states that would think otherwise, and there's probably going to be lawsuits. I believe there's 9 or 10 states that have put it in their constitution. Alabama was the last in 2016. I think we'd be 10 or 11, somewhere in there, 10. And this is somewhat of a reaction to what's going on with trying to eliminate it. And just to your point, this happens all the time, but employment at will, which you were describing earlier, Representative Towns, that is the right to hire and fire. That is separate from right to work. This is just saying that your employment is not conditional on paying union dues or not. You have the choice whether to pay it or not. So it's separate.
All right, Mr. Chairman, thank you, members.
Thank you, Representative Hodges.
Thank you. And I heard the comment, Tennessee's economic success. And so my question would be, is success for who? Because we lead the country in minimum wage jobs. We lead the country in every statistical category that talks about poverty. And we're a welfare state, right? We receive more money from the federal government than we give. So what success are we talking about? What are we dominating in besides poverty?
Thank you, Mr. Chairman. Representative, if you look at studies, they have shown that you have real higher income growth in right to work states. You have more employment growth in right to work states, more population growth in right to work states. I think Tennessee was just the #1 U-Haul state of people moving into our state using U-Hauls. And so I do think that we are a magnet for people wanting to come here and live in a society with a free economy. We do have a long way to go in certain areas, but right to work states have proven to be better economically in these areas that I just mentioned.
Representative Hodges, you got to follow up.
Yes, sir. Because since 1947, we've been a right to work state, and we're struggling in all these categories. Again, we're ranked #1 in minimum wage jobs. We're ranked in the top 5 of every category for child poverty, income levels. I mean, we do a terrible job in taking care of working class families in Tennessee. To say that we're successful here when more Tennesseans are on welfare than the vast majority of other states is crazy to me. And I don't consider that success. So thank you.
Mr. Chairman?
Yes.
I believe it's the Mackinac
Brown.
study. The Mackinac study in Michigan showed that if an apple and an orange, if you really look at the cost of living and other factors, and you have some points there that there are areas where there's higher numbers, but when you add everything up, the Mackinac study, I believe it's 2014, we can get this to you, shows that we're actually doing better than many other states.
All righty. Representative Thompson.
Thank you, Mr. Chairman, and thank you, gentlemen, for your presentations. I keep hearing about the federal law that's been passed in the House, and there have been there have been several presidents, there's been a lot of Congresses that are, tend to be very much pro-labor and very much anti, right to work from 1946 on to the present time, yet it's never been overturned. What gives you the idea that the current Congress would overturn right to work?
You want to go? Well, they're trying to. I mean, that's what's happening. That's why we're here. When this came to our attention 2 years ago, we went, why would we do that? Someone even said, one of my labor attorneys said, aren't we piling on? And we were like, okay, do we really want to do this? And then we looked at what's happening in Virginia. There was a judge in Indiana that overturned their right to work law, or voted or decided a year after they passed their law in 2012. And that got our attention. The Supreme Court unanimously reversed it. And just to add this is something that hasn't come up in the other committees, but we have made so much progress with labor law. And I've told Billy this a few times, where this is not stopping anyone's right to organize. This is just saying what I said earlier. But we've made so much progress in labor law at the federal level and the state level. You all passed the Pregnant Workers Fairness Act that got worked out of last year. I mean, we're adding protections year after year after year. And so we believe that this is a bedrock law for our economy, for workers who want to come here, like Mr. Owen said, for choice and freedom. And that's just, we feel strongly about it.
All right, thank you for that. For our last question of our witnesses today, Chairman Zachary, and then we'll go back in session.
Thank you, Mr. Chairman. Real quick before, I'm going to ask, just for the simplicity of it, and plus you guys are through a plexiglass, so I can't see you that well. I'm going to ask you a question in a second, Justin. But I think it's important for clarity, and being on finance, I have some of these statistics really readily available to me. But Tennessee has the fastest growing median income in the Southeast. We currently rank #1 in the Southeast, ahead of Mississippi, Arkansas, Louisiana, Alabama, Kentucky, South Carolina, and throwing West Virginia into median income. Our median income in Tennessee is $52,375. The closest to us is South Carolina, just above $52,000. Then there's a significant drop to Kentucky, Alabama, Louisiana, on and on in that order. So just to bring clarity to in terms of income in our state. But let me just ask quickly, just to make sure I'm correct, and Justin, just correct me if I'm wrong in how I see and understand this argument. It's important to remember that we are a republic. We are not a democracy. We're a republic, which puts the value on the individual. And so in a right to work state, we simply are saying that a union cannot force the individual to become a member or to pay dues. They cannot force that. So we are solidifying in this constitutional amendment that we're simply saying that we value the right of the individual. And this is not an attack on the union. This is not about the union. This is about the individual and protecting the individual liberty and the rights of the individual. Can you simply tell me if I'm correct in that assessment?
Mr. Chairman, Representative, that is correct. This also prevents the employer from violating that individual right, allowing that person to make that decision or not make that decision. It protects their decision to join a union and pay dues just as much as it protects their decision not to join in a union and pay dues. And I believe that fundamentally that's their right to make, not anyone else's.
Thank you, Mr. Chairman.
Yes, sir. Thank you all for being with us today, both sides, both points and counterpoints. We're going to call Chairman Todd back to the podium. And if you have any, I've got Representative, we're not, okay. Now we're back in session. Now we're going to do some business. Any questions for Representative Todd before we move forward? Representative Todd, you want to surmise quickly here as the hour is fleeting?
Yes, sir. I appreciate that, Mr. Chairman. I will say this is not about me. I have a small business in West Tennessee, very small number of employees. My dad was a member of a labor union for many, many, many years, most of my growing up years into my adult years. I have a brother who is a part of the labor union that was even represented here today, and a nephew. This has nothing to do with damaging labor unions whatsoever. This is strictly, as Representative Zachary said, about a person's right to work or right to choose whether they're part of a labor union or not. That's simply all this is about. And it enshrines that with the threats that we have from the federal government and federal overreach that I think all of us would agree. this enshrines that in our Constitution to protect us. So I appreciate your consideration, sir, and I renew my motion.
All right, we have a question for you from Representative Thompson. I saw your hand.
Thank you, Mr. Chairman. Thank you for the presentation. You know, a lot of us are really concerned that adding this to the Constitution is simply trivializing the Constitution. That this has been in our code for 74 years, and there have been Democratic supermajorities, during much of that time, but nobody sought to try to overturn it or had a serious effort. So the thought is, in the future, what if somebody else? What if our legislature changes to the point that we want to abolish right to work, and that's one of the motivations for this amendment, as I understand it. Let me ask you: do you believe that we as representatives should listen to our constituents and try to do the will of our constituents?
Thank you, Mr. Chairman. Thank you for the question. I certainly believe we are here to represent our constituents, and has been stated, the vast majority of our citizens believe this right should be enshrined in the Constitution, and this effort is just to give them the ability to vote on that.
Representative Thompson.
So suppose, we'll be a right to work state as long as any of us are here, and probably as long as any of us are alive. But in the future, sometime in the future, suppose the attitudes of Tennesseans change, they want to do that. Why do we have to put this in the Constitution? It's done fine for 74 years in the Tennessee Code Annotated. So why don't we just keep it there? It's done fine, and it will not change anything.
Representative Todd.
Thank you, Mr. Chairman. I mean, I think the reasons have already been stated here. I'd just be repeating those. So I just renew my motion, sir.
Representative Moon, I saw your hand.
Thank you, Mr. Chairman. I move previous question.
All righty, we've got a with any objections to previous questions. Seeing none, we are going to be voting on House Joint Resolution 72. The result of this vote will, if it passes, will go to Finance Subcommittee. I want to thank all of our people that testified today. I did a great job of presenting your positions on it. So all those, House Joint Resolution 72 in favor, please say aye. Aye. All those opposed? No. I believe the ayes have it. House Joint Resolution 72 goes to Finance Sub. Any other business? I recognize you, Representative Sparks.
Yeah, real quick, the name of that book is Ending Our Uncivil War, A Path for Political Recovery and Spiritual Renewal. The reason I say this, and I hope everybody's listening, y'all listen up now. I had protesters at my house at 4 a.m. Those protesters freaked out my wife. 7 cop cars at my house. Those protesters were paid for by some left-wing radical group. That's not civility. Those people are welcome to call me. AJ can call me. Billy can call me. Jim can call me. I don't know if any of y'all ever dealt with that at 4 a.m, but I don't like people trying to intimidate my wife. So for the record, thank you, Jim. Thank you, AJ. Thank you, Billy, for what you do.
All righty. And with that, we are adjourned.